claims that they have. We know of 2 lenders who are making very strong suggestions that that could be the case. We're not disclosing who they are or when, but with the calls that are set up, with knowing the sources of where this is from, this could be very much a feasible Plan B stroke Plan C that we have. So the need for a weekly webinar, yes, it's to update on where we are in the industry, to update all things on Woodville. We are conscious that we have got a lot of clients, a lot of advisors, and to update everybody all the time is difficult. And apologies for those that have not had responses in a timely manner, but the webinar is intended to get this message and any updates out to everybody. But just circling back to the beginning, please, if you have colleagues, if you have fellow advisors, clients, if you have partners or friends who have invested, who haven't had the verification to come through to this webinar, we will be sorting that out and have their access done for next week. So I'm going to hand over to my partner now, Anne-Marie, who again, many of you know, who will update on where we are with funding. Thank you all.
Thanks, Pete. So, hello everybody. Hello to both people we've already spoken to, and hello to new advisors and investors, in the sense that we haven't yet had the opportunity to speak. I'm just going to do what a woman normally does, and I'm just going to correct something that Pete said that's wrong. Okay.
I'm used to that, it's okay.
Yeah. So it was, in the update, Pete said that the Supreme Court decision was handed down this year. It wasn't, it was handed down in August of last year. Just want to clarify that, because obviously I mean, it's a matter of public record anyway. Okay, so I've done that bit. I also want to sort of touch on a point that Pete sort of gave you a little brief overview on. The FOS scheme, having the 5-6 delays that we had over the course of 2025 and into 2026, I just want to sort of go a little bit deeper into that comment, because I think it's really important for everyone to understand what and where the money is. Where is your money? Is your money safe? Okay. Your money has been invested in cases, largely PCP cases. We do have a small book of other cases. Okay. So they get invested in cases. The law firms draw down money from us, and we invest. They give us all the details of the cases. We do some verification and due diligence checks on those cases, and then they get submitted. Now, we've been a PCP, probably one of the pioneers that went into it, okay? And we've been in it from the day that you used to have to litigate them, and that meant that we had to spend far more money on them, lend far more money on them, and they took longer to settle, which is why, as Pete mentioned, the FOS scheme was brought in quite early. Back in the day, in sort of around 2005 to 2008, we had what's known as PPI, which was the precursor to PCP. And I'm sorry for the 3-letter acronyms: Payment Protection Insurance. PCP is a personal contract purchase. And PCP has largely mirrored what happened back then. So when this redress scheme was announced, Peter and I actually went more heavily into PCP, because our job is to de-risk these cases that we lend on, okay, to the best of our ability. And a redress scheme means that, one, they require far less money, and two, as Pete briefly mentioned, with the benefit of a Supreme Court judgment, these cases cannot be challenged. So the validity of these cases are there. So anyway, back to the point. The money is invested in these cases. There is nobody in this land that can do anything about the stay. It's called a stay on these legal proceedings. And what happens when they stay something? It means just that. The case doesn't move forward. It doesn't get cancelled. It doesn't move backwards. It stays where it is. And the reason that the courts, and then ultimately the, I can't remember if it was the FCA or FOS actually, put the stay on them, is because they needed to have the settlements made in a uniform manner under a framework with a methodology about how you calculate the settlement levels. And all of those things were part of the legal and then regulatory challenges and arguments that were held throughout 2025. So your cases are there. the law firms owe us the money on these cases. The law firm owes us the money for the late interest, because when we lend this money to the law firms, let's say for ease of reference, we lend on a 12-month term, the 12 months interest is charged up front. We then have that 12 months worth of coupon ready to repay you all, and that's what we were doing. Throughout the sort of latter part of 2025 and into 2026, Peter and I have been using a lot of our own resources to then cash flow the business. We had quite a nice sort of book of cases, which we then sold and we put that money in. Peter then had access to other funds and he's also invested those funds. And I only tell you that to show you that, you know, we have made sure that those assets are there and how we've managed to survive this problem, that had we known then that we were going to get 5 or 6 delays, we would not have continued to invest in PCP. So we want to reassure you first, more than anything, those cases are there. The law firms can't pay us, not because they're not performing, and we can't not pay you, not because in that sense we are not performing. Contractually wise, we understand we're not performing, but from a reality perspective, it's important that we explain that nobody is getting settlements. There's not one law firm or CMC in this country, claims management company, in this country that can change this result. Nobody can change it. So we'll come back on a bit later into this point that I want to sort of come back to and explain, you know, that what happens next, but we'll come on to that later. So the current status of the FOS scheme is there are thousands of cases banked by our law firms on behalf of their clients, of which we have funded them. They're not going anywhere until these settlements occur. There, you know, I'm happy to sort of confirm that one of the calls that Pete referred to about the 2 of the banks that want to consider settling these cases prior to the FOS scheme, that's the first one is happening on July the 6th. I don't have a date from the law firm of when the second one's going to occur. What that may do is that may release money from those particular cases, you know, for those particular lenders sooner than the outcome of the upper tribunal decision, which is where the current legal challenges happen. So this upper tribunal challenge, it's likely to be heard in October. We don't have a firm date yet. We'd all hoped it was July, but it didn't get onto the timetable. So, as Pete pointed out, you know, the defendants are arguing they shouldn't pay as much and they shouldn't pay before 2014. The claimant side challenge is arguing that you're not paying enough. So there's a very, very big decision to be had for these defendants. I'm sure they're all in their boardrooms as we speak, debating these issues, getting legal advice on them, because they have to, sorry, I know people are raising their hands. I will deal with that a little bit later on. So, sorry, I lost my train of thought because of that. So they have to make a judgment call now. Do we actually settle now and know what we're settling about, or do we settle later and there's a potential they could pay a lot more? Now, I want to go in a bit of an Armageddon sense here now, okay, in terms of the FOS scheme. The FCA have publicly stated, and everything I'm telling you about these things, you can find it all online. Don't take my word, take Pete's word for it. Google about the FOS scheme, about the delays. You know, I know we've sent links out and all of those kind of things. I just wanted to sort of say to you, Google about the delays on the FOS scheme. Or, you know, there's obviously different opinions and, you know, of what the consequences are, etc. But I want to go on an Armageddon about the FOS scheme. If the FOS scheme did not go ahead, because the FCA said if the parties that are challenging this do not accept the decision that it will ultimately be handed down by the upper tribunal later this year, they are minded to say there will be no scheme. And I just want to say to you, to explain to you what that actually means. Does that mean these cases, you know, that anything will happen? No. What will happen is the same claim will be made to the defendants. The defendants will still have the same amount of time to accept or reject their liabilities. They will still have the same amount of time to then pay out on those cases that they accept. The 2 main differences that occur if the scheme is scrapped is that the cases will still then go to FOS where the defendants refuse to settle them. And it's at that point that 2 things can happen. One, the FOS are not under a redress framework, so they can take a bit longer to make an adjudication. And we have a Supreme Court decision. So on that basis, I don't see how any organisation could go against the Supreme Court decision. okay? So the cases again then will be found in favour. The difference will be, and this is another risk that these banks have to consider, is that the Ombudsman can then look outside the scope of a framework because they're not bound by those framework rules, and that they could pay at least 55% more in compensation per claim. Okay, that's a lot of money. There are millions and millions of these claims. There's also on a certain bank of these cases an argument for rescission, and a rescission means that you're put into the place you would have been had you not taken out the finance. So all of your interest payment, all of your capital payment, it'll be reduced slightly for the use of the vehicle, but they're at risk of paying the whole of that money back. They're also at risk of paying a higher level of statutory interest, because the Ombudsman, again, under a framework, has to abide by, I think it's 2 or 3% statutory interest. And under a FOS complaint that is not bound by a framework, it's 8%. Some of these claims are over 20 years old. They'd be 18, 19 years old, the most oldest ones. That's a lot of statutory interest over a lot of months. And we found in PPI that sometimes, and David, who's my colleague, he's on the call, I'm not going to ask him to speak, but David, he worked with me right back as far as the PPI days, and we would often see some settlements where the original amount of PPI that was actually paid was dwarfed by the amount of historic statutory interest that had to be paid. So the point I'm making is that these cases are not going to go anywhere. They're safe. There's a Supreme Court judgment, but we just have to wait and see what happens, because they're not obliged to make these settlements. And because they're not obliged to make these settlements back to our law firms, yes, we could take default action, event of default action against our law firms, but it's the same sort of message that we're trying to sort of convey to you all. We cannot do anything about it. The law firms cannot do anything about it. We cannot uplift our book from one law firm and put it into another and they're going to get a better result. That is not going to happen. Until this stay and these matters are decided, nobody can do anything. And that's why we haven't been able to repay you. That is the key reason why we're here today. We've used as many of our resources as we could to make up the difference, because we got ourselves largely through to March with a few delays. But then the further delay, we just couldn't overcome that further delay. So what are the alternatives? What are the solutions? So, right now, the only two solutions are available to us is, one, to put the company into administration. And I'll come back to that point later. Two, to be able to source alternative funding to then refinance out anybody that has a maturing loan note, whether already outstanding or whether it's coming in the next few months. To then let us put new lending out, and that new lending creates income, because we can only pay our coupons from income. We can refinance your assets, because a bit like a house, if you sell a house, the buyer and the seller's solicitors, the buyer's solicitor receives the money. The seller's solicitor receives the money from the buyer's solicitor, and then they have to move that over to their client. Our assets are the cases. It moves exactly the same way, okay? So on a refinance, there's a book of cases that will be put up for sale, and then that money must go to the underlying client. So I'll use Peter as my example. If Peter had a book up for sale, we have to give an undertaking to the funder that we will pay Peter, and then we have to prove that we've paid Peter, because only at that time can that funder take good title. So that is the mechanism for us refinancing you. This finance is very, very important, because without the finance, we either have to put it into administration or we have to wait for FOS, okay? The reality of waiting for FOS, if we don't have any other form of funding, FOS scheme settlements, unless these two banks start settling early, will not happen until at best the end of this year. Likelihood is next year, throughout 2027. So without this funding, that's the two options that we've got. Now, I appreciate that our contractual obligations will put us in breach of many of our funding agreements with you all. But it's our job to try to protect your assets and the company's assets to repay you 100%, okay? So because we're not expecting you all to wait to 2027, we have been working on this new funding line for a long, long time now, many, many months. We first spoke to these funders, I believe, July or August last year. And I just want to put that into some context, okay? These funders, they are behemoths. They are such huge companies. They have investment committees, they have legal teams, they have risk analysis teams, they have due diligence, everything. Everything moves at snail's pace, okay? So even with them knowing that we needed to refinance people out, this has still moved very quickly. We have an SPV, which has an American funder behind it. It took us pretty much almost 2 years to the day from the first time we spoke to them do all of those things, get them all signed off from the investment committee, last minute glitches, etc. It took us almost 2 years to the day before the money landed in our account. So I just want to stress that that is normal in this world. It might not be normal to anybody that's making an investment personally, but if you make a personal investment, you don't have investment committees and due diligence teams and legal teams and all of those kind of things. It's a much swifter process. There are less parties involved in that decision making. So I tell you all of that just so that you can understand what's going on in the background. We're not sitting here doing nothing. We are still running the business, which is a full-time job on its own, but subsequent to that, we are still very reactive and very available to these people and to other funders that we've also been talking to in the background, which again, I'll talk more about that later. So the point I'm making here is, what is the solution? Well, the easy solution for Peter and I would be to put it into administration, just hand over the book, and then you all get paid next year. We don't want to do that. We're not taking the easy solution. And there's two reasons why we're not taking the easy solution. One is because all of our wealth is in this company. We have nothing outside of this company. I don't mind personally telling you, I live in a house with a mortgage, my car is leased. I've got 2 kids, I've got 6 grandkids. I'm going nowhere, okay? And Peter is pretty much of the same sort of standing as myself. So that's why, on the first face of it, we want to save Woodville. Secondly, what happens in an administration? Well, one, you absolutely will be delayed in getting your payments because, like I said, the administrator can't make this any different, the same as anybody else. So the administrator will simply sit back and say, you will wait until the full scheme settlement's open, I should say, because the scheme is technically open. You will wait for these legal challenges to occur. You will wait until the law firms pay us. We will keep in touch with the law firms, and then we will distribute money to you on a monthly, quarterly, whatever they desire basis. That's the reality about an administration. The second reality behind an administration is the administrator always gets paid. Their charging is anywhere from £200 to £500 an hour. They will spend a lot of hours on administering any administration. And what that means is they will get paid and it comes from somewhere. So what we are trying to stress to you all is, whilst we appreciate that this is not a great situation, we appreciate that you need your money, want your money, you don't have to give us a reason. If your loan note matures or your coupon is due, it's your money. I'm willing to say on record, we are not trying to deny any of our obligations to any of you. We are fully cognizant of our contractual obligations to you, and we are fully cognizant of the fact that we are in breach of some of those obligations with some of you. If not all of you on this call, I don't know. So on record, I am stating we are not denying any of your contractual rights, okay? We are fully accepting of them, but we are equally being very, very open with you. Some might even say I'm being a little bit blunt, and forgive me if I am, but I am trying to make sure that I enforce the message of what happens if we just have to wait for FOS, or if we had to go into administration. It's not in everyone's interest. We want you to get